So, a big question right now is just how much power and influence should social media companies and other big tech companies have over what's on their platforms? Some people say that they're private companies and they should have the freedom to choose exactly what's on there with impunity. Other people say that they've become so essential that people need to be allowed to stay on them, and that restrictions on what is said need to be minimal, maybe even down to the standards of complying with the First Amendment itself. We've seen these questions come up anytime anybody is removed from Twitter and it's perceived to be unjust. Especially when it's a larger name or a larger personality. We saw it particularly during the election with the censoring of the Hunter Biden laptop story, with the censoring of various tweets by Donald Trump, and the eventual removal of Donald Trump after the election, but prior to the inauguration of Joe Biden. And that is going to play in here. And this is Justice Clarence Thomas of the Supreme Court giving some hints and laying maybe some groundwork pathways to answering these questions, both legislatively and through the courts. I'm going to walk you through it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that stuff, click that subscribe button, hit the notification bell so you don't miss any videos, okay? All right, so this is a case that is actually decided by the appeals court back in 2018. This has been sitting around waiting on Supreme Court appeal, and a lot of us have been watching to see what was going to happen here. And the results at the Supreme Court level, at least, are a little bit disappointing and frustrating. This was the case of Donald Trump blocking journalists. Donald Trump was blocking journalists on Twitter. Haha, you can't follow my account anymore. You can't comment on my stuff. It was done. So they sued, and they said that that was the government depriving them of their right to free speech. Donald Trump was preventing them from speaking in a public forum. And that went to the appeals court, and the appeals court said, no, Donald Trump, you cannot block people from your Twitter account because your Twitter account is where you make official statements on occasion from as the president of the United States to the people. And since that is an official account, then you cannot censor people. You cannot block them from speaking their mind or from being able to see your comments. Even though people raised the alternative point is that anybody can see his stuff. You just have to log out of Twitter or go into an incognito window or something to be able to see past the block. But they argued that their ability to speak with their name on his tweets was an essential First Amendment protection. The appeals court says yes, and that's where it stopped from 2018 all the way till April 5th of 2021. Which is an amazing amount of time for this to sit there, especially with all of the stuff that happened during the election and real questions about whether or not the government can or can't do this. We even saw some parallel cases on places like Twitch, where the U.S. Army Twitch channel was blocking people's accusations of war crimes committed by the U.S. Army. Can they censor their comment section on Twitch? These are big questions with regard to the First Amendment, and we were hoping for a resolution here, and let me disappoint you. The Supreme Court said it's moot now because Trump's no longer in office. And their legal reasoning for it to be moot is actually pretty good. It's just frustrating to see this case be called moot because this is an unanswered question. In fact, Ken Paxton is being sued about this right now because Ken Paxton, the Attorney General of Texas, has blocked people on Twitter. And so now he's being sued in the same way that Donald Trump was sued, and we're going to see this issue again. And of course, we're going to continue to see this again and again until the Supreme Court answers the question. However, the question here was, can Donald Trump block someone on Twitter? And Donald Trump is no longer as president, and Donald Trump is no longer president. So the question is moot. But Justice Clarence Thomas does us a solid, a true bro. He writes out an opinion, a concurring opinion saying, yes, this is moot and it should be dismissed. However, However, and it's the however that we're going to talk about today. I've highlighted specific sections of this text, and we're going to go through those and hit the whole thing or hit the highlights of it because this is the stuff we want to talk about. So I've explained to you in probably more words than the Supreme Court used what was going on leading up to this. And now we're going to get to Thomas's commentary on this. So he starts off with his intro. I write separately to note that this petition highlights the principal legal difficulty that surrounds digital platforms, namely that applying old doctrines to new digital platforms is rarely straightforward. And that is the problem here, right? This isn't a simple question of was this Twitter platform used in an official capacity and therefore is censoring it part of the government actually restricting free speech. I mean, on a surface level, they say yes. Thomas points out here that it's kind of hard, especially now that Twitter has completely removed Donald Trump from the platform. It's hard to say that Donald Trump actually had control over that account in the way that the government would typically exercise control in these issues. So when a government, the analogy he uses when a government rents like a hotel room, for example, to hold a public meeting, or a hotel conference room, I should say, to host a public meeting, they can't just kick people out. They have to let them in. The government has the ability to kick people out of the hotel conference room, so therefore they're not allowed to. However, in some other capacity where the government isn't in charge of being able to exclude people, when the venue itself can exclude people, then the government doesn't have the power to exclude or include anybody, and that is not a government act, right? So that's the question here is, was Donald Trump blocking people on Twitter actually a government act if Twitter has the ability to remove Donald Trump's account entirely as he is the president of the United States? At the time of his removal, he's still president, and Twitter says, nope, you're gone. So if they can do that, how can he be said to have enough control over it? And it gets to be a really complicated question because we have a mixed level, and that's the issue. So Thomas goes on, if part of the problem is private concentrated control over online content and platforms available to the public, then part of the solution may be found in doctrines that limit the right of a private company to exclude. Historically, at least two legal doctrines limited a company's right to exclude. And this is the baffling thing about conservatives right now, especially, who are saying, well, they're private businesses, they should be able to do whatever they want. There are tons and tons of private businesses who are not allowed to do whatever they want. That's not a thing that actually exists anymore in our current situation, in our regulatory structure. Private companies have all sorts of restrictions over them all the time. And just as a simple example, open a sandwich shop and try and refuse service to people of a particular race. And you'll find out very quickly that no, companies cannot deny service to whomever they want for whatever reason. Now, they have a broad list of reasons to refuse service, but there are specific restrictions. And that's just one example that we're going to talk about here. That's the public accommodation example. I've been talking about it a little bit recently. Thomas is going to flush it out here, but this is the weird aspect of conservatives who have suddenly taken on a pure libertarian perspective, but only in regards to corporate structures. And this is not a proper way to look at the current regulatory climate. I can agree in theory that private companies in a vacuum should be able to do whatever they want, but we don't operate private companies in a vacuum. And we've given all sorts of things to tech companies to insulate them, to allow them to proceed in the ways that other private companies have been given similar insulations, but also responsibilities. We haven't put any of those responsibilities on the shoulders of the social media companies that we're protecting. Thomas is going to get to it. Sorry, I'm talking ahead here, but that's because this is such an important topic, and Thomas does a really great job of laying this stuff out. Okay, back to it. First, our legal system and its British predecessor have long subjected certain businesses known as common carriers to special regulations, including a general requirement to serve all comers. So a bus line or a railroad can't say, you're a conservative, you don't get access to railroad. Wait, what? They can't do that. That may be a surprise to some people. They don't get to exclude people from that. if you're transporting goods and services, if you're transporting communications, like your phone line can't shut you down for being a liberal, for example. They can't listen in and be like, oh, this guy's a Biden voter. Nope, not on my network. It doesn't work that way. These are common carriers of either people, goods, or communications, and they're restricted. Now, does a common carrier of a communication kind of sound like a social media network? Kind of does to me. At that point, a company's property is but its instrument, the means of rendering the service which has become of public interest. Now, Thomas will go on to explain how public interest is really not a helpful standard because everything's a public interest at some level. But the way they get around this with common carriers is to say when there's a dominant market share, that's sort of the biggest look into what is a common carrier. When they control a huge portion of the market and they have, by that control, have the ability to suppress competition, that's when we start to get into common carrier status. And think of it this way, as Thomas would lay out if I read the whole opinion, Google controls 90% of search on the internet. 90% of search is through Google. And Google has a huge profit margin, something like 30% profit margin. That's, if you don't know about profit margins, the margins are what induce people to enter into the business because there's a big area to make a lot of money above your overhead. Now, some huge companies have very low profit margins, but because they're so huge, they get a ton of revenue. They make a ton of profit. Oil companies, stuff like that, but they have a lot of overhead, so their profit margin might be 5, 6, 9%. When you're getting into a 30% profit margin, every dollar you put in gets amplified in a way that is way different than any other company. There should be more competition to search, but there isn't. And part of that, Thomas lays out, means that probably the cost of entry is too high for other companies to compete. So when that happens, maybe we need to look at common carrier regulation. So he says, for example, governments have tied restrictions on a carrier's ability to reject clients to immunity from certain types of suits. These are those protections I was talking about before, or to regulations that make it more difficult for other companies to compete with the carrier, such as franchise licenses. The immunity to a particular type of suits that he's talking about is actually in regards to telegram companies. Telegram companies were protected from defamation outside of having actual knowledge of a defamatory statement being telegrammed, because they wanted them to transmit stuff without going through and editing the content or censoring people's communications. And they wanted everybody's telegrams to be transmitted. The exchange for that immunity is, look, you got to service everybody. You don't get to pick and choose based on characteristics or political beliefs or religious beliefs who you're going to service. You're insulated from liability here. And if that sounds a lot like Section 230 protections for these big tech companies, that's because it is. It's a lot like it. The only difference is we have not given the responsibility to serve all comers to the big tech companies in the way that we did to telegram companies. And that's lunacy. It's lunacy because CDA 230 was actually passed in 1996 when there was no idea what social media would actually become. There was nothing like it at the time, at the scale and scope that we have it now. And so they probably didn't foresee the requirement of doing something like this. And so that's the big difference here. But what Thomas is talking about now is legislative. That means we're going to have Congress. We're not going to get much help on that, but we'll get to it in just a minute. Make sure you watch all the way through this video, by the way. I should have said it earlier. This is important stuff. By giving these companies special privileges, governments place them into a category distinct from other companies and closer to some functions like the postal service that the state has traditionally undertaken. Second, governments have limited a company's right to exclude when that company is a public accommodation. This concept, related to common carrier law, applies to companies that hold themselves out to the public but do not carry freight, passengers, or communications. So this is, like the store that you go into is a public accommodation, right? Like they don't have some test at the door to let you in. You just get to go in. Now, if your behavior in the store is particularly egregious, they can ask you to leave temporarily, or if it gets really egregious, they can ban you forever. But they have to be careful on how they do that. They can't do it because you're a particular race or from a particular country or because of your religion or your marital status, for example. Internet platforms, of course, have their own First Amendment interests, but regulations that might affect speech are valid if they would have been permissible at the time of the founding. The long history in this country and in England of restricting the exclusion right of common carriers in places of public accommodation may serve similar regulations today from triggering heightened scrutiny, especially where a restriction would not prohibit the company from speaking or force the company to endorse speech. And the idea that Twitter being forced to keep someone on their platform is somehow an endorsement of the speech is so backwards and ridiculous that I can't understand how we've actually gotten there in any logical capacity. Twitter is not the speaker. In fact, Twitter's protections under Section 230 necessitate that it not be the speaker, that speech comes from somewhere else. So this idea that Twitter is somehow endorsing a particular level of speech or a particular type of speech or speaking through force is nonsense. That is not the case here. And by forcing Twitter to accept all comers as a common carrier, we are not limiting Twitter's right to speech. Because if Twitter is speaking, they don't have 230 protection, but they're trying to walk the line between both of these places. We're speaking by removing people from our platform that we disagree with. However, we're not speaking, and therefore it's not, we don't have any tort responsibility for it under 230. Get out of here. There's a fair argument that some digital platforms are sufficiently akin to common carriers or places of accommodation to be regulated in this matter. Yeah, that's an understatement. Okay. Much like with a communications utility, this concentration of power, of search, what he's talking about here is the fact that Twitter is controlled really by a small group of people, Jack Dorsey and a few others. Facebook, Mark Zuckerberg and a few others. Google CEOs. A small amount of people control basically everything. So, much like with a communications utility, this concentration of power gives some digital platforms enormous control over speech. When a user does not already know exactly where to find something on the internet, and users rarely do, Google is the gatekeeper between that user and the speech of others 90% of the time. Facebook and Twitter can greatly narrow a person's information flow through similar means, and as a distributor of the clear majority of ebooks and about half of all physical books, Amazon can impose cataclysmic consequences on authors by, among other things, blocking a listing. It changes nothing. This is the line of the entire thing, man. It changes nothing that these platforms are not the sole means for distributing speech or information. Boom. A person always could choose to avoid the toll bridge or train and instead swim the Charles River or hike the Oregon Trail. But in assessing whether a company exercises substantial market power, what matters is whether the alternatives are comparable. For many of today's digital platforms, nothing is. Nothing is. Gab, Parler, Minds, the Fediverse, they're all wonderful. None of them even come close to competing with Twitter or Facebook. And I know they'll quote unquote get there, but will they? Will they actually get there? Or do Twitter and Facebook have enough power to sufficiently snuff them out of the greater market and leave them snipping for 2 to 3% market share? That's a big question. If the analogy between common carriers and digital platforms is correct, then an answer may arise for dissatisfied platform users who would appreciate not being blocked. Laws that restrict the platform's right to exclude. Now, this is still talking about legislative things, and that is well and good, but if Congress doesn't pass a law, that's not going to be very helpful. Okay, now we're going to get into a little bit more, right? The similarities between some digital platforms and common carriers or places of public accommodation may give legislators strong arguments for similarly regulating digital platforms. Yet Congress does not appear to have passed these kinds of regulations. To the contrary, it has given digital platforms immunity from certain types of suits with respect to the content they distribute under 230, but it has not imposed corresponding responsibilities like non-discrimination. That would matter here. None of this analysis means, however, that the First Amendment is irrelevant until a legislature imposes common carrier public accommodation restrictions, only that the principal means for regulating digital platforms is through those methods. For example, although a private entity is not ordinarily constrained by the First Amendment, it is if the government coerces or induces it to take action the government itself would not be permitted to do, such as censor expression of a lawful viewpoint. And this is key here. Because if the government asks or induces a private company to do something that the government can't do, then it's acting potentially as a quasi-state actor, and in that case, they're bound by the First Amendment. Under this doctrine, plaintiffs might have colorable claims against a digital platform if it took adverse action against them in response to government threats. And he says government threats here because that's the example that he used, thinly veiled government threats. And if you think about this, there's been plenty of that in the congressional hearings where the senators have been asking questions of these companies and talking about regulating them if they don't do what they want. In fact, Democrats are talking about regulating Facebook and Twitter if they don't ban more people and suppress more speech. That's the government threatening Twitter or with action if they don't do what the government wants that the government can't do. That's right up the alley of Clarence Thomas's example here. But there are other examples. And in fact, in this case, in the Trump case, back to the case at issue, there was an example where Donald Trump didn't block anybody from accessing his tweets. He doesn't have the power to do that. He has the power to press a button which requests that Twitter block someone. And there's a big difference there. Twitter has the power to restrict Donald Trump's access to the block button, certainly. A simple line of code that creates a database of user accounts that are not allowed to block people or for whom blocks have limited or no effect at all. That would be something that Twitter could probably whip together pretty quickly. And yet, they allowed it, right? Twitter did the bidding of the government, blocking people from this. Now, Twitter wasn't a party to this suit, probably because the attorneys hadn't considered this course of action. They wanted to go after Trump. They weren't really thinking about Twitter. They're like, oh, Trump blocked us. Twitter didn't do anything. Plus, Section 230 gives Twitter immunity from actions like this. Except, it may not if the proper claims were brought before it. And in this case, that's what Clarence Thomas's criticism of this suit was. They're not bringing in the proper claims here for us to properly assess this. So, but think about this, because this is a big thing. I saw Tim Pool talking about this on Twitter today as well, and it's probably from this opinion. I talked about it the other day when this opinion came out, and I read it on a live stream, but the idea that Trump blocked people on Twitter is false. Twitter did the blocking. Trump just requested it. So the government makes a request. Twitter acquiesces. The government wouldn't, as we can see, if it were a government-controlled space, they would not be allowed to do this. So Twitter has acted at the behest of the government to do something unconstitutional. That means we need to be targeting Twitter on these types of lawsuits that involve public officials blocking people. That's the tree to bark up. Thomas is laying it out very clearly for us. As Twitter made clear, the right to cut off speech lies most powerfully in the hands of private digital platforms. The extent to which that power matters for purposes of the First Amendment and the extent to which that power could lawfully be modified raise interesting and important questions. Thomas is sounding he's blaring the trumpets here. There are questions to be resolved here. Ask the right questions. Bring in the right parties. Trump wasn't the right party because he didn't ultimately have control over it. Twitter did. Twitter's the right party there. And this is the big question on big tech censorship. Just how far do we let them go to censor all communications of a particular stripe? Right now, it would be perfectly legal for Twitter to block all Republican candidates and no Democrat candidates. That's the system we've set up. And that doesn't seem acceptable. In the same way, Twitter could block all Democrat candidates and no Republican candidates. And if you ask people about that, they'll say, oh yeah, I'm sure I'm okay with that. Because they know Twitter won't do that. right? They know Twitter won't lean that way. They're pretty sure they won't lean the other way. It's a very safe answer to say, we're okay with that. But would people actually be okay with it if it happened is completely different. But hey, I don't know. I wanted to bring this case to you and break it down to its really important parts. And as a wrap-up summary to that, yes, these companies can be regulated because the government has regulated similar companies all the way back through the founding and back into England. We're talking colonial times, pre-colonial times. These types of companies that deliver goods, people, and communications have been regulated. They have been regulated prior to the founding. They have been regulated through the founding. They have been regulated all the way through today. Common carriers have been regulated. Places of public accommodation have been regulated. They are required to take all comers. Places of public accommodation, this was the entire, one of the entire thrusts of the civil rights movement. African Americans wanted access to all businesses, not access to some comparable separate business that wasn't actually that comparable. They wanted equality, and the government was supposed to be doing this. The government had been set in there to ensure the equal access to the protection of law, to the rights of public accommodation. That was part of it. And the fact that we ignore that now, we're ignoring it now because we don't see the color of the people who Twitter's blocking. We don't see the political makeup of the people Twitter is blocking. Heck, we don't even know, because once they're off Twitter, outside of having a particular political alignment, or I should say a particular level of following, we can't know. We can't know at all unless someone brings it to our attention. And if Twitter can suppress that, who knows how many people they block? Who knows how many people never get a voice? And that's something that would be unacceptable pretty much anywhere else in America. Clarence Thomas has laid it out, but hey, why don't you drop a comment down below? Tell me what you think. I would love to hear your thoughts in the comment section. And until next time, peace. Peace.